Today we'll be talking about arbitration. So that's our plan today. So let me share my slide so you can join me. Now let's discuss the concept arbitration. Arbitration is the settlement of dispute in a cooperative society. This dispute must touch the business of the registered society. The dispute must be between present or past members and the committee members or any officer in the cooperatives or in the cooperative. The director of cooperative is the arbitrator of cooperative societies, but he can delegate this power to any officer in the department of cooperatives or the cooperative assistant. What is the procedure for appointment of an arbitrator by the director? When there is a dispute in a registered cooperative society, the members will apply for arbitration to the director through the area officers by completing a form tagged that the Form A. They will appoint an arbitrator with Form B. The arbitrator so appointed must be an impartial judge. He must have a good knowledge of cooperative laws, principles of cooperation, and the bylaws of the society. Apart from this, he must be equipped with the knowledge of court proceedings, the workings and constitution of the societies involved in the dispute. By this appointment, the arbitrator becomes a magistrate. Arbitrators and non-members, how are they supposed to relate? When a dispute arises between a society and a non-member, the auditor, who is the arbitrator, has no power to hear the case. The solution to this is to take such case to the law court. Similarly, if a dispute arises between the society and an ex-employee of the society, the dispute is better settled at the law court, except he agrees to submit himself to arbitration. Now, let's talk about activities of the arbitrator after appointment. The arbitrator will open a file from which all correspondence relating to the arbitration are written, or the ones received are kept. The next step is to serve notice of hearing to the parties involved. This is usually done on Form C, and at least 10 days notice shall be given to them. It is important for the arbitrator to ensure the notice of hearing is received by the respondents and the complainants. This will be done in the following way. 1, the notice may be given to the person concerned by hand. This is one of the surest way of ensuring the notice of hearing has been received. Another way it can be done is that it may also be left at the last place of abode of the person or in the business premises of the person concerned. The notice may also be given to an adult member of his family or the family head. If the address of the person is known, the notice can be sent to him under a registered cover. The sender must obtain a receipt of registration showing that it has been sent. The notice can be pasted at a conspicuous place where it is sure the person will read it. Now, this can be his abode, this place you paste it, or his business premises where the notice had been delivered personally. The serving officer shall demand for a receipt from the receiver. Where it was sent by registered cover, and it was rejected, it will be assumed the notice has been received. In any case, when it had been assumed or the notice has been assumed to have been received, arbitration can proceed, and any award given after the arbitration will be binding on the parties. If there is any need for an extension because the arbitration cannot hold on the proposed date, the arbitrator must apply to the director of cooperative for an extension, given the reasons for the application. Now, the conduct of the arbitration itself. Disputes may arise as a result of non-payment of loan taken by a member of a society, past member or deceased member of the society. A dispute may also arise if a committee member, any officer, the secretary, the treasurer defrauds the society or misappropriates the society's money. Disputes can be settled in a conducive place, such as in the cooperative premises, in the hall, have prospects, which can be the society. The arbitrator must have invited the complainant, which can be the society, and the respondent, which can be a member or another society. The arbitrator must have known what the dispute is and must have gone through the relevant records to inform himself about the dispute. The arbitrator will first and foremost invite the complainant to state his case with a support from the witnesses, if there are any, who will support the statement of the complainant. This will also be supported by exhibits by the complainant. The witness will be named. The witness will be named witness 1, 2, 3, 4, just for identification. He will maintain his number even when recalled, and the exhibits will also be named exhibit A, B, C, D accordingly. The evidence will be recorded in first person. The exhibits or documents should be initialed by the arbitrator. Evidence presented to the arbitrator should be supported with relevant documents like the relevant books and records. In like manner, the respondents will be allowed to state their side of the case. This must be supported with material facts, not just by hearsay from the witnesses and the presentation of exhibits, and witness will be named as stated, as we have mentioned before, according to, we give them a name and a tag and a number. And the exhibits and the document will be initialed by the arbitrator. The exhibits and the evidence presented should also be supported with relevant documents. When the arbitrator is satisfied that all statements have been heard and recorded, all witnesses examined and cross-examined, all exhibits produced, and all relevant documents presented, he can then close the recording of the evidence. However, before this, the arbitrator must ensure that the proceeding is recorded in first person. He should ensure that the original documents belonging to the society should not be attached or submitted during the proceeding, but certified through copies. It should be noted also that when a party dies before the date of the hearing, the case against the dead party should be struck out. Now, let's talk about how awards are given. The arbitrator must table all statements, evidence, exhibits of the respondents, complainants, all witnesses, and consider the importance of the exhibits and documents presented. With all these, he can now give an award. An award can be likened to judgment given in a law court. This award comes after the arbitrator must have made his findings. The award or judgment is always recorded on award form D. In giving this award, the arbitrator should use facts based on the arbitration. It must not be based on his judgment. It must be based on justice, equity, and good conscience. The award must be read and served on each party. An award must declare a party right, not guilty, and made to receive compensation from the guilty party. In a situation where the society is found guilty, she may be asked to make good her indebtedness to the member or members, in whatever case it may be. If in a cooperative thrift and credit society, some members are indebted to the society and are willing to repay, thereby resulting in an overdue loan, the arbitrator may give an award ordering the loan defaulters to repay the loan within a given period of time, or else their property will be sold by a public auctioneer to settle the members' debt. Now, distribution of the award. Copies of the award of the arbitration will be given out as follows: 1 copy each to the 2 parties, 1 copy each to area and zonal officers, 2 copies together with 3 copies of typewritten proceedings. A handwritten copy plus the arbitrator's file will be sent to the director of cooperatives. Now, appeal against the award. At this junction, the director of cooperative will receive the award. Before the director approves the award and ensures it is effected, the party that is not satisfied with the award can appeal to the commissioner. If it's at the state level, or the minister in charge of cooperative at the national level, within 13 days of the award. Now, the minister or commissioner will now invite the director of cooperatives in charge for briefing. After this, the minister or commissioner will decide whether to reverse the award or uphold the award. The decision of the minister or commissioner shall be final. Now, enforcement of the award. If an award is not heeded to, that is, if the member refused to pay their debt to the society on the given dates, then the society in whose favor the award had been given can now proceed to the law court to enforce the award. This will be done when the party in whose favor the award is given sends a copy each of the original award from D with affidavit forms collected from the law court to the arbitrator. When the arbitrator receives these, he will complete the affidavit forms and attach the copy of the original arbitration award from D and swear to the affidavit before a commissioner of oath at a competent court of law that the award is done in good faith and without bias, and that the director of cooperative had approved the award. So you see how the enforcement goes. The arbitrator would then send the document that is the affidavit sworn to and the arbitration award from D back to the successful party, who now will refer them to the law court through a practicing lawyer. He will file this case in a court of competent jurisdiction and consequently pray the court to confirm the award. After this step, the court may give the unsuccessful party the last chance to respect and honor the award by giving him a deadline. If this deadline is not heeded to, then the successful party will settle the debt and a court bailiff will execute this. Now, what is it? Let's talk about the concluded arbitration. A concluded arbitration is an arbitration which has been conducted, award given, enforced, and the desired result, that is recovery of all debt, has been accomplished. Okay, lack of enforcement of arbitration award. In some part of the country, cooperators complain of their inability to secure enforcement of arbitration award. Even the directors of cooperative in some states of the federation complain of their inability to get the support of the courts to ensure arbitration awards are enforced. In some quarters also, the courts consider awards given after arbitration to be invalid or inferior, or that the arbitrators are not competent under the law to carry out arbitration. But what is very clear is that directors of cooperatives or any of his staff appointed to carry out the assignment is the most qualified to carry out the exercise. Now, lack of enforcement of arbitration award. This is because they are equipped with knowledge of, now the staff is the most qualified to carry out this arbitration award. This is because they are equipped with the knowledge of cooperative law, principles of cooperative, the bylaws of the society, and they understand how the business operations of the cooperative society are carried out. These areas may not be known to a lawyer or judge in the law court. They are not specialized in cooperative. It is also clear that Nigeria Cooperative Society Decree 1993 gives room for cooperation on legal matters between the minister or commissioner and the director of cooperative on one part and the court on the other. This is stated in section 50 of the Nigerian Cooperative Society Decree of 1993. With this in mind, to enforce arbitration award in any part of the country should not be a problem. If there is a problem, it means somebody somewhere is not doing his or her job properly. In certain cases, it is the members of the concerned cooperative society that do not make the moves or steps to ensure arbitration awards are enforced. Now, what are the advantages of arbitration over law court proceedings? Except where a competent arbitrator is not chosen or where the arbitrator is already biased, arbitration has no disadvantage over court proceedings in settling dispute among cooperators. One should remember that disputes that require arbitration are disputes that affect the business of the cooperative society. Advantages of arbitration. 1, arbitration is quicker than court actions. Arbitration is quicker than court action. What do we mean by that? It is devoid of all the legal formalities like getting the services of a legal practitioner, accused being accompanied by the police, long case adjournments, and lacking in arbitration. Number 2, arbitration is less complicated. With some of the reasons mentioned above, arbitration is less complicated. Bureaucracy is avoided in arbitration. Filing of unnecessary forms, the involvement of court registrars, standing in court cages to make statements, bribery, and so on and so forth are avoided in arbitration. Number 3, arbitration is normally handled by professionals. The director of cooperative, or the person appointed by him to carry out arbitration, is usually a person who has an expert knowledge of the subject matter, the cooperative laws, the principles of cooperation, the bylaws, and the day-to-day running of cooperative society. He is usually a person with vast cooperative knowledge. Number 4, arbitration is usually done in privacy. The proceedings of arbitration is usually done within the members of the cooperative society. Non-members and pressmen are not usually invited. The sitting is not usually made public, not publicized in the radio, television, or newspapers. Number 5, the venue of arbitration is always conducive. The venue of arbitration usually is located where the members and the parties concerned can sit and relax comfortably. It can be done in a hall, in the premises of the cooperative society, on a playing ground, on the field, and so on and so forth. Even the members can be served food and drinks during arbitration. Number 6, no judges and lawyers during arbitration. Both the plaintiff and the respondents do not need to get the services of lawyers during arbitration. This makes it cheaper and easier. Number 7, it is easier and cheaper to organize. Expenditure is limited before, during, and after arbitration. All expenses involved in court proceedings are avoided during arbitration. Now, let's talk about the steps for settlement of dispute usually taken before arbitration. Several steps are usually taken before arbitration takes place. Such steps include contacting the parents, the elders in the village, the town where the person on whom dispute is to be declared lives. The wife, the friends are also usually contacted so that they can appeal to him or her to make good the matter that is causing the dispute before arbitration is introduced. The area officer of the society to which the member is indebted, if this is the reason for such arbitration is to be declared, can write the debtor to pay off the debt at a stipulated time, or else a dispute will be declared on him or a judgment will be made thereafter, which cannot be contested in the law court. It will be stated also that non-compliance with the award, which will be enforced by the law court, will be understood as contempt of the court. The end result will be the sale of the personal property of the defaulter by a public auctioneer to liquidate the debt and other expenses that may come into being in the process. Now, seizures of loan defaulters' property by the management of some societies and unions and neglect of arbitration. In order to ensure quick justice, the management of some societies or unions advocates seizure of property until defaulters pay. In cases where the loan defaulters cannot repay, the seized items are sometimes auctioned to recover the societies or the union's money. This action is contrary to the process of arbitration, which is the normal way of recovering loan in the cooperatives. At times, this seizure of property is done in company of some law enforcement agents. Also, we have demand for collateral securities and sureties by the society. Some society asks loan applicants, especially cooperative truth and credit societies, to present collateral security and two sureties who must be members before they can be given loans. This development is as a result of unpatriotic attitude of some members who take loan from their societies and run away or refuse to. So far, so good. We have presented the problems facing cooperative audit organization in cooperative field work as it affects the running of the cooperative society. We have also discussed the concept of arbitration. And we said arbitration is the settlement of dispute in a cooperative society. This dispute must touch the business of the registered cooperative society. The necessity of appointment of an arbitrator by the director in carrying out their activity and the conduct of arbitrator. We also talked about the advantage of arbitration over law court proceedings. We highlighted the steps for settlement of disputes usually taken before arbitration is enforced. Okay, that's about it for today. I will, like I say always, attempt some of these questions, try to discuss the advisory duty of the cooperative manager, discuss the conduct of inquiry and the preparation of inquiry report. Try to discuss the appointment of an arbitrator by the director and activities of an arbitrator. Until next time, thank you for listening. Thank you for listening. If you have learned from these videos, click the notification button. Please give it a thumbs up so that others can see it or will see it. Always remember to subscribe if you have not done so. Until next time, keep learning.